afternoon, one and all present here. Today is your opportunity to build the tomorrow you want. With this positive note, it is my great pleasure to welcome you all to the National Seminar on Intellectual Property Rights, Need of the Hour, jointly organized by the Research and Development Cell, Internal Quality Assurance Cell of Rajapalayam Rajus College. Now, I would request respected dignitaries, professors to rise for Tamil Thai World.
நீராறும் கடலுடுத்த நிலமடந்தை கெழிலொழுகும் சீராறும் வதனமன திகழ் பரத கண்டமிழில் தெக்கணமும் அதிசிறந்த திராவிடனர் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அணித்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறம் இருந்து சிறமருந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
A beautiful smile is the best universal welcome. Now, I would like to invite Dr. Ph.D, Coordinator of IKC, to deliver the welcome address.
Very good afternoon to everyone present here. I am proud and privileged for this National Seminar on Intellectual Property Rights that IKC has organized for this year. And though it is new to us, there are eminent resource persons for us to give us an awareness about it. So first of all, I warmly welcome the resource person, Mr. Arunkumar of Department of Mechanical Engineering, Assistant Professor, a certified patent agent of Ramco of Technology, for having raised this occasion and going to give us an elaborate deliberations on the patent and property rights. Welcome you, sir. And I also welcome Dr. G. Balaganesan, Senior Technical Officer, Central Skill Training and Fabrication Facility of IIT Madras, who will be on the online platform after the session is over by the speaker one. I welcome you, sir. I also welcome our principal, who is always a supportive and helping hand to us every time whenever we offer or we ask for anything to be done. He is very supportive to us at all times. Thank you very much, sir, for your constant guidance and support. I also thank and welcome Dr. Manjula for doing the organizing plan so well. Whatever is done at the right moment, she comes out with all cooperation. Thank you, ma'am, and welcome you. And then I warmly welcome HODs of all departments, the staff member, for which the intellectual property rights is being organized. Thank you for your presence and cooperation, participation. Knowledge is vital for rights transmission and transition. So in that part, anybody's the intellectuality should be patent, should be given copyright. So that is for the sake of the intellectual property rights seminar is being organized. So let us get involved in it and be benefited and take this to the classroom so that the young entrepreneurs will emerge with all their intellectuality. So thank you all and all. Welcome you all again.
Thank you, madam, for your generous welcome. Now, I would request our principal, Dr. D. Venkateshwaran sir, to honor the chief guest with a shawl and memento. Thank you, sir. Felicitate the small initiative. Initiative is the intention that persists in a person by cause. May I request our principal, Dr. D. Venkateshwaran sir, to give felicitation for this national seminar.
Dr. Ph.D, Coordinator of our college IIT. Today's resource person, Patent Agent, Assistant Professor, Department of Mechanical Engineering, Ramco Institute of Technology, Rajapalayam, staff members of our college. Good afternoon to all. First of all, at the outset, I congratulate IQAC members and coordinator for arranging this national seminar on intellectual property rights. Many of you know fundamental rights. Our constitution provided fundamental rights to our citizens. Initially, constitution provided 7 fundamental rights. In course of time, the constitution removed one important right, that is called the right to property. Many important the rights we enjoy: freedom of equality, freedom of speech, and other important the rights. Now recently, one important the rights, they became very popular among the industrialists and other academicians, that is called IPR, intellectual property rights. What is mean intellectual property? The intellectual property may be divided into 2 kinds. One is called the rights related to copyrights, and other one is the industrial rights. Industrial property, intellectual property. Every one of you have idea. That idea is very novel to others. We should protect our idea. That idea is called intellectual property. There are many legal laws which help us to protect the intellectual rights. Intellectual property, the rights, refers a legal rights granted to the inventor and the manufacturer of the manufacturer to protect their inventions or manufacture the products. Today, the resource person will explain what is the meaning of intellectual property, how to safeguard, protect our intellectual property. The government provided some important legal protection to protect our intellectual property. So it is a very, very essential topic. All the staff members should know what is the meaning of intellectual property. In this, a few words, I felicitate this function a grand success. Thank you for giving this opportunity.
Thank you, sir, for your gracious words of felicitation. The key to growth is the introduction of higher dimensions of consciousness into our awareness. Now, I would call upon Mr. P. Satish Kumar, Assistant Professor of English, to introduce the chief guest.
Very good afternoon, Honorable President here. And really, it's my pleasure and my own privilege to stand before all of you and introduce our chief guest of today's session, Mr. Arunkumar, who has graciously accepted our invitation to join us today. Thank you, sir. And today's chief guest, Professor Mr. Arunkumar, is currently working as an assistant professor in the Department of Mechanical Engineering in Ramco Institute of Technology, Rajapalayam. He is also a certified patent agent in Government of Tamil Nadu. He has completed his undergraduation in Mechanical Engineering from KGISL Institute of Technology, Coimbatore, with distinction, and master graduation from National Engineering College, Kovilpatti, with distinction, and also he was the topper of this batch. Now he is pursuing his Doctor of Philosophy in Solar Thermal Energy at Anna University. He was worked as an assistant professor in Francis Xavier College from 2015 to 2016. And our chief guest has more than 7 years of experience in IP and entrepreneurship field. He is also a certified domain scholar by NPTEL in patent and IPR domain. And also, further he has shared his IP and entrepreneurship expertise during more than 50 occasions in more than 30 institutions through guest lecture, workshop and webinar. He has also successfully completed more than 15 online courses on IPR and entrepreneurship in MOOC platform, and his learning skill still continues. A beautiful line at last. To be inspired is great, but to be inspiration is an honor. With this beautiful quote, I feel privileged to welcome and introduce our chief guest of today's session, Mr. Arunkumar. Thank you, sir, and thank you for giving me this opportunity. Thank you.
Thank you, sir, for your brief introduction. If your action inspire others to dream more, learn more, do more, and become more, then only you are a leader. I would cordially invite our chief guest, Mr. Arunkumar, to deliver the keynote address.
Good afternoon all. So I would like to thank the management of this institute as well as my own institute for giving me this opportunity to share what I have learned in the past 7 to 8 years related to IPM. So as far as the requirement is concerned, so how the agenda of today's session is going to be that we'll be understanding what is actually a property and the importance of the property, and then we'll get a deep understanding about what is actually an intellectual property is, and how it is going to be protected with the help of intellectual property rights, and we'll understand what is the need of this intellectual property rights as far as the present scenario is concerned. As the topic rightly says, IPR, the need of the hour. So because in recent 5 to 7 or 8 years, the entire country is talking about intellectual property rights. So what is actually the need of this intellectual property? We'll have a deep understanding about that, and then we'll just have an understanding of the position of our country when we compare with the entire world. That is, with the we'll have a comparison with other countries, and based on the comparison, and we just understand what is the need of intellectual property rights as far as our country is concerned, and then we'll get an understanding about the different types of IPR. Because as far as IPR is concerned, many of us we know the type of IPR to be either a patent, copyright, or trademark. So only these steps. But actually in India, we are administrating 8 different types of intellectual property rights. So we'll understand what are those 8 different types and what all those 8 different types are meant for. So with that understanding, we'll conclude the entire session. So with this, we'll start the session. So a small disclaimer before getting into the session. So here, for getting a better understanding about intellectual property rights, I have used various examples by means of the company name, logo name, and brand name. And the sole purpose of using all those brand names or logo names or company names is only meant for getting a better understanding. And I'm here not to promote or demote any brand here. So with this disclaimer, we'll get into the content. Next slide. Next. So this is what the agenda is going to be. Next. Yes. So I put a request here. Let us make the session somewhat interactive, so that for the next 1 hour we learn together. Because this interactive session will help in turn me also to get a better understanding about intellectual property rights further. Now the question here is that I have shown 2 images here, 2 monuments. So what are those 2 monuments? So one is towards left, Tanjore Big Temple, obviously, and towards right, Taj Mahal. When we look Taj Mahal, who is the person comes into our mind? Obviously Shah Jahan, right? And what about this Tanjore Big Temple? Rajapalayam. Now the question further here is that actually the purpose of constructing a temple or a worship place is to worship God. Now what is the name of the God residing in Tanjore Big Temple? What is the actual name? So only 1 or 2 answers we are getting right. See, once again I'm stressing here. The purpose of constructing a temple is the value of property. So if you are able to create a property and that property, if it is going to serve the society, then our name will be getting remembered. So obviously every one of us, we know about Tiruvallur, right? But how many of us know the third or fourth generation of our family? Not exactly. We don't know where Tiruvallur was born and how he was brought up. So we don't know anything about Tiruvallur. But how we are able to remember Tiruvallur? Only by means of Tirukural. So that is the property he had created. So that is the importance of property. We doesn't know even the third and fourth generation of our own family, but we are able to recollect, or we are able to take the name of Tiruvallur to all the generations, almost 2000 or 2100 years back. So that is the value of property. So if we are going to create any property, and if that property is going to serve the society, then our name will be getting registered in the history. So that is the importance of property. So with this understanding, we'll just get a deeper understanding about an intellectual property. So next slide, sir. So onion. So obviously we'll be knowing that at least twice the time, if I'm right, because of this onion, the entire government have got changed in India. See, the price of onion at present is 30 to 40 rupees. So what was its price around 8 or 10 months back? It rose up to 120 or 130 rupees. So onion is a commodity which can be called as a tangible property. Tangible in the sense we can touch and feel the property. So this mic I can touch and feel. It can be called as a tangible property. Whereas the display for this through this projector, it cannot be called as a tangible property. The display is a technology. It can be called as an intangible property. Now think, onion is a property. We are using it in our day-to-day life. When the price of onion rose from 20 to 30 rupees to up to 150 rupees, what was the scenario was? The next slide. Next slide. So what actually happened to this tangible property is that people started to steal onion. Right? Now once again I'm stressing here, onion is a tangible property. We are using it in our day-to-day life. When price of onion rose from 30 rupees to 150 rupees, people started to steal onion. Now think about your intellectual property. It doesn't have any tangible form. Until otherwise it is residing as an idea, still it remains as an intangible form. When there is a provision, when there is a pathway for stealing and tangible asset, now think how far your intangible asset is having a protection. So we need to protect your intangible assets, which is called as your intellectual property. So for protecting our intellectual work, obviously we need to go for certain protection, which is called as an intellectual property rights. I put it in a more simple words. Being a faculty member, we used to give assignment for our students. So we used to give a common assignment for all the students. Some of the students, they'll be dedicatedly involving and developing that assignment. But few students, they'll be copying and then they'll be submitting it. Now, if a student who actually developed the assignment, he gave his assignment or her assignment to his friend. Now what happens is that the friend copies the assignment and submits it earlier ahead of his friend. Now as a faculty, what will be thinking? The person who copied the assignment have completed his first. Now what is the provision for the student who actually created the assignment to prove that he or she has first developed the assignment? That is not possible. See, now the intangible property can be easily stolen from one person. So if you want to legally protect your invention or your intangible assets, you need to have some legal system, and that legal system is called as intellectual property rights. So next slide. So to conclude with, we understood what is actually a property and what is the importance of property and what is meant by an intellectual property. So any form of intangible assets can be called as an intellectual property. To put it in a more simple words, any property that comes out of our intellect can be called as an intangible assets or an intellectual property. And the right which helps us to protect our intangible property, that is our intellectual property, it is called as intellectual property rights. I'll put a question here, sir. For example, you are having a bike or a car. So how you will be able to prove that the bike or car belongs to you? With the help of RC, obviously, the registration certificate, because the registration certificate will be having
the bike name, the model name, the color of the bike, the registration number of the bike, the number of the engine, the owner address, and complete detail of the owner. So if you want to prove that any property belongs to you, obviously we need some documentary evidence. In a similar way, if you want to prove that any intangible asset also belongs to you, so obviously you need to have some legal right or a documentary evidence, which is called as an intellectual property right. So as far as India is concerned, so there are 8 different types of IPR. So we'll have a detailed understanding of those 8 different types of IPR. So before that, we'll just have some statistics and we'll understand what is actually the need of this intellectual property rights. So what for this intellectual property rights are meant for, and in what way it is going to give a benefit as an individual. So obviously, if you are owning a home, what can we do with that home? Either we can reside in the home, we can rent it, we can lease it, or even we can sell it, or we can destroy and reconstruct the home. So all these facilitations or all these eligibilities are given for an individual based on our legal system. So the legal system is giving certain benefits for the property owner for tangible assets. In a similar way, the same legal system is going to give the complete rights to the inventor or the creator in terms of an intangible assets. So that is what called as intellectual property rights. So if I own an intellectual property right, so what I can do is that with the help of intellectual property right, so obviously I can own the right, I can sell the right, I can lease it, I can license it, or even I can destroy it. So whatever I want to do, the legal system is going to completely give the benefit for the creator or the inventor of the property. So that is the benefit of an intellectual property right. So next slide. So to further have a better understanding, we just understand what is actually the further need of this intellectual property. The first one is it prevents infringement, because if you are owning any right, so obviously that will give a platform to you, so that no one else can copy your inventions or creations. So copying is called as infringement here. So if you are having any intellectual property rights, so obviously that intellectual property rights will be helping you as an inventor or a creator to prevent infringement. So no one else can copy or no one else can resemble your invention. And next one is it gives complete right to the inventor legally, as we saw on the previous slide. You can own it, you can sell it, you can license it, or you can lease it. So whatever you want to do, the complete right is given for the inventor by means of this intellectual property. And third one is it minimizes R&D in a company. So I just put another question here, sir. So we came across this COVID scenario. What was the vaccine we were using at the maximum? What is the name of the vaccine? Covishield. So Covishield, what was the vaccine we were using? Covaxin. So who invented or developed Covishield, sir? Serum Institute have got the license from the original inventor or the creator. They marketed and they developed here. So they manufactured and marketed it. But who is actually the inventor of Covishield? So Covishield was actually developed by Oxford University. So what Serum Institute did is that they got a license transfer from Oxford University to manufacture and to market in India as well as neighboring countries. Now who actually developed Covaxin, sir? Bharat Biotech, exactly. See, Covaxin is an indigenous vaccine which was developed in our country. So நம்ம நாட்டிலே முழுக்க தயாரிக்கப்பட்ட ஒரு மருந்து. So in spite of being an indigenous technology, an indigenous vaccine developed by our own country, but many of the people doesn't use Covaxin. So instead we prefer Covishield. What could be the reason? Trust issue, okay, but அதுக்கு முன்னாடி ரொம்ப பேசிக்கான ஒரு லாஜிக் இல்ல ஆக்சுவலா நம்ம மக்களோட மனநிலை என்ன அப்படின்னா ஃபர்ஸ்ட் எது வருதோ அதை அப்படியே நம்ம பிராக்டிஸ் பண்ண ஆரம்பிப்போம் இல்லையா. ஸோ கோவிஷீல்டு ஆக்சுவலி என்டர்ட் இன் டு த மார்க்கெட், பீப்புள் ஸ்டார்டட் டு கெட் த டோஸ் அண்ட் இன்ஃபேக்ட் அவங்களுக்கு சைடு எஃபெக்ட்ஸ் எதுவும் வரல அப்படின்ட்டு by means of word of mouth it got spread to the entire country, and that is why most of the people had used in அப்படின்னா Covishield. Now what I'm trying to say here is that see what actually Serum Institute did is that instead of spending much more energy on R&D, what they did is that they simply got the license transfer from the original inventor, and they got the market benefit. So ultimately, what is the need of intellectual property right? To get a market benefit or a monetary benefit. So that was earned by Serum Institute when compared to Bharat Biotech. So I doesn't say that Serum Institute haven't involved in R&D, but still they got the market advantage by means of this license transfer. So that is the importance of intellectual property rights. So if you are being a creator and if you are not having any facility to manufacture and market the same means, what you can simply do is that you can transfer the license as far as our book is concerned. So we being the author will be developing the content, will be transferring the right to the publisher, and now the publisher will be completely taking care to produce the book, as well as they will be going for marketing. So as author, what will be getting? Will be getting the royalty per book for the sales of the book. So that is the benefit of intellectual property right. So if you are going to have any intellectual property right or an IP asset, so you can easily transfer it. With the help of the transfer, you can minimize the needless investment in R&D, as well as you can get a market benefit over it. And the next one is it improves the innovation index of the country. I'll show that statistics in our next slide. So we have a comparison of our country with other countries in terms of innovation index. And next one is it helps the inventor to provide the licensing agreement as far as this Covishield is concerned. So as far as Covishield is concerned, Serum Institute got the license from the original developer and they got the market benefit. So that is what the next benefit or the need of this intellectual property right. And the last one is ultimately it gives a monetary benefit. So if you are going to construct a new home, what is the purpose? To earn a rent. So with the help of the rent, you can improve your that is a monthly income, or by means of lease you'll be getting a monetary benefit. In a similar way, whatever the benefit you are going to get for a tangible assets, the same benefit you can get for your intangible assets also by means of intellectual property rights. So these are all some basic need of this intellectual property rights. Now we'll have a comparison of our country in terms of innovation index. See, world's most populous country is so 2 or around 10 days back, UN declared that, or they are predicting that India to be the most populous country in the world with a population of more than 141 crores, and they are predicting the population of our country to be more than 27 lakhs when compared to China. And as far as our country's government is concerned, they have initiated the process of census. So once the census process is over, we'll be getting the official population count of our country. So whatever it may be, now India has become the most populous country in the world. And it is also being said that India is a country with lot of young minds. So that among the total population, at least 55% or 60% of the population is less than 40 years. See, with this young mind and with this young human resource, obviously no other country is having this much of human resource, that too with a young force. So in spite of being this young force, we can see the position of our country, it is at 46th spot. So as far as the Global Innovation Index 22 is concerned, our country had jumped to 40th spot. But still, we need to move a lot, because being the one of the youngest country in the world, so we need to move a lot ahead, so that in this knowledge-driven economy, we can position ourselves in the driver's seat. Because when we talk about economy, so obviously China comes into the play, and China அப்படிங்கிற ஒரு நாடு we used to talk for the past 10 to 15 years, not more than that. So how that was made possible by China is that only because of this intellectual property rights. Because if you go to a shop and if you want to buy any plastic items, so what will be there, sir? Made in China. See, they have dominated our market. They have used their intellect. They have protected their intellect, and they have commercialized it. And based on the commercialization, they have led this global knowledge-driven economy. In order to utilize the same, we also need to protect our intellectual work, and we need to commercialize it, so that we can also become one of the leaders in this knowledge-driven economy. So why I am stressing here, or why the government is focusing more on this IPR for the past 5 to 8 years is that because this young force has to be utilized effectively. So if this young force is not utilized for the next 2 decades, what is going to happen? All this young force is going to become an old age group. So அப்போ ஒரு old age group போனோம் அப்படின்னா நம்ம மூளை சொல்றதை உடம்புனால செயல்படுத்த முடியாது. So obviously physically we'll be getting weak. So that is why the government is focusing on this IPR, and they are encouraging all the young minds to protect their intellect through this intellectual property rights, so that future la enna panikalam appadina we can commercialize it. So that is the need of this intellectual property rights. So to position our country in this innovation index at the top 10, we need to work hard and we need to protect this IPR. So as far as this ranking is concerned, it doesn't mean that India is not having innovation. We do have innovations and inventions, but where we lag is that we lag to protect our inventions and innovations. We just understand the same with the help of another statistics which has been released by WIPO. The next slide. So as I told, 8 different types of IP are there. We just have a detailed understanding in the forthcoming slides. We just have a small statistics comparison across the world. See, as far as patent is one of the IP, and the total number of patents filed in the year 21 was 32,76,700 applications. Patent applications have been filed across the world. And you can see what is the contribution of China. Around 46%. 46% of the applications were filed by China. And you can see the numbers, it is almost 15 lakh applications. Among total 32,76,000 applications, 15 lakh applications were filed from China. And you can see the numbers of India, it is 56,000. 15 lakh enga irukku parunga, 56,000 enga irukku parunga. So in spite of being the populous country in the world, and we used to compare ourselves with China in economy, so அப்படி இருக்கும்போது இந்த ஒரு parameterல we can compare our country. So we are a way behind. So we need to work a lot and we need to put all our effort to come again. And next slide, sir. And the next form of IP or comparison எடுத்துக்கலாம், trademark filing. So trademark பொறுத்த வரைக்கும் across the world the total number of applications filed were 1,71,98,000, among which 54% of the applications were filed in China. And you can see the numbers of India. So total of China 93 lakh applications have been filed, and in India it is just 4,24,000. Almost 20 times nammaloda jastiya file pannirukanga. So we need to put lot of effort to increase these numbers. And next one, sir. And this is related to industrial design and another form of IP. Adu ennagadha detailed ah paakalam. So as far as industrial design is concerned, the total number of applications filed were 13,87,000, among which 7,70,000, almost 56% of applications were filed by China. And we can't see India here. India oda numbers inga illa. See, that is where we are lagging. We fail to protect our inventions and innovations. So we do have inventions and innovations, and we do have quality inventions and innovations, but enga nama lag aagum appadina, we used to fail in protecting this intellectual assets. Seri, appo quality wise India endha level la irukudhu அப்படிங்கற ஒரு சின்ன comparison the same WIPO statistics மூலமா we compare it with என்ன அப்படினா China. So next slide, sir. See, you can see 4 graphs here. So this 4 graphs indicates details related to patent. So towards left you can see 2 graphs which is related to India, and towards right side it is related to China. And the top la irukkudiya rendu graph enna appadina number of patent applications applied in India and China, and towards the bottom it is number of patents granted in India and China. We just have a comparison here. See, in all the graph you can see 3 different colors. One is orange, and other one is dark green, and other one is light blue. So what are all these 3 colors indicates is that we just take the example of India. So for India எடுத்துக்கிட்டீங்கன்னா the orange color indicates, இந்த first graph சொல்றேன், orange color indicates number of patents applied by other country people in India. So the dark green or dark blue indicates number of patent applications filed by Indians in India, and the light green indicates number of patent applications filed by Indians in other countries. So that is the difference between these 3 colors. Now you can see in India who is dominating. Obviously the other country people. See, India is a huge market with a population of more than 141 crores, and that market is being effectively utilized by other country people, but still we are lagging behind to utilize our own market. The lagness is because of lack of awareness to protect our intellectual assets. So that is what the need of the hour. And you can see the dominance in China. Chinese are dominating in China. So that is the beauty of the country, and that is why they are one step ahead of us in terms of intellectual property. Not even one step, a large steps ahead of us. And we just have a comparison in quality of this invention, sir. See, the graph at the bottom indicates the patents granted. See, if I have been granted a patent on this day, on 2nd May 2023, means I should have filed the applications at least 3 to 4 years back. Which means, if I'm going to file an application today, my grant status will be known to me after 3 or 4 years. So, we can just compare statistics with India and China. See, as far as this 2020 is concerned, we just have a data about number of patents granted in India which are filed by Indians. You can see these numbers. That is these numbers. So in 2020, you can see the number of patents granted in India which are filed by Indians is 5,000. 5,000 patents have been granted. If it is being granted in the year 2020 means obviously it should have been filed in the year 16 or 17. So 2016 or 17. And in 2016 or 17, the number of applications filed by Indians in India is approximately 15,000. So here you can see 16 and 17. So it is approximately 15,000, which indicates that approximately 1 in every 3 application is getting granted. So the quality of our invention is that 1 out of 3 is getting granted. The same statistics we compare with China. In 2020, the number of patents granted in China which are filed by Chinese is approximately 4,20,000. And if it is being granted in 2020, it should have been applied in 16 or 17. And in the year 16 or 17, you can see the number of applications. It is approximately 12 lakh or 13 lakh. So which also indicates that 1 in every 3 applications are getting granted in China. So in quality wise, we don't have compromise. See, both the countries are having the equal quality, but where do we lag is that we lag in numbers. This lag in numbers is because of lack of awareness. So that is the reason, and that is why the central government also, as well as all the state governments, they are promoting and they are focusing a lot and they are encouraging every individual to file IP rights. See, when I came for the session, I got the feedback that some faculty members were having a background of English, Tamil history. So you need not to worry. See, inventions or patents or any forms of IP, it is not only restricted for a science background people. It is meant for everyone. Even if you are able to address a small problem in the society with the help of your intellect, then that can be protected under this IPR. So now, with this deep understanding, we get into the different types of IPR that is being administered in our country. So next slide. So as I told you earlier, 8 different types of IP are being administered in our country, and I have listed here. So one is patent, trademark, copyright, industrial design, geographical indication, trade secrets, semiconductor and integrated circuit layout registry protection. So I have, in short form, I have mentioned it as IC, and I have not listed one more here. The last one is plant variety and farmers' right protection. So in India, 8 different types of intellectual property rights are being administered. So IPR அப்படிங்கிறது patent, copyright, trademark இது மட்டும் கிடையாது. There is further other scope. So totally in India we are administrating 8 different types of IP. So now what we do is that we just understand what are all these different types of IPs are meant for, and நம்ம கிட்ட இருக்கக்கூடிய ஒரு intellectual asset எதுல protect பண்ணா நமக்கு effective-ஆ இருக்கும். So that our own profile is going to enrich, as well as the institute profile is going to enrich, as well as the department profile is going to enrich, and ஒரு cumulative effort வரும்போது the same will be reflecting in our country's profile also. In that way, we'll understand what are all those different types of IPs are meant for. So next slide. So the first one is patent. So what is a patent is that patent is a type of intellectual property right which is granted for inventions and innovations. கண்டுபிடிப்புகளுக்காக இந்தியால கொடுக்கப்படக்கூடிய உரிமை என்ன அப்படினா காப்புரிமை. So patent is called as காப்புரிமை in Tamil. So patent in India is granted for an invention or innovation. And பொதுவா என்ன ஒரு misconception இருக்குன்னு பாத்தீங்கன்னா, patent அப்படிங்கற ஒரு விஷயம் கொடுக்கப்படணும்னா அந்த கண்டுபிடிப்பானது it should be in a tangible form அப்படினு நம்ம சொல்வாங்க. It is not so. So it need not to be tangible in nature. Even for an intangible asset also, a patent is being granted. For example, I am standing in front of this podium. For example, you assume that the price of the podium is to be around 10,000 rupees. Now what I am going to do is that I am going to create a novel process. With the help of that novel process, I am going to manufacture the same podium with same quality, with same appearance, with the same feature for a price of 2000 or 3000 rupees. Now what I have done is that I have brought down the price of this podium with a novel process from a price of 8000 rupees to 5000 or 4000 rupees. Now this novel process can be patented. So patent is not only restricted for a product, it can be even for a process also. And that product can either be a tangible form or in an intangible form also. So for example, patent அப்படிங்கிறது பெரிய விஷயம்லாம் இல்லை சார். So just ஒரு சின்ன எக்ஸாம்பிளோட I'll explain here. I have shown an image here. So you just ignore that wheel. அந்த இமேஜ்ல இருக்கக்கூடிய wheel ignore பண்ணிருங்க. Ignore பண்ணிட்டு அந்த remaining அந்த component மட்டும் பார்த்தோம் அப்படின்னா it is actually called as shovel. So we would have seen this shovel in most of the construction sites. It is meant for lifting weight from one place to another place. Now what is the problem actually with this shovel is that, see, being a right-hander, I am a right-hander. My maximum power will be lying on my right hand. When I am going to handle this shovel, what is going to happen is that naturally my right hand goes to the handle of the shovel and my left hand is going to be at the middle of the shovel. So my left hand will be at the middle and my right hand will be at the handle. Now if I am going to lift the weight from one place to another place, in spite of being a right-hander, where the maximum load will be bearing? Obviously in my left hand. And similarly vice versa. If I am going to be left hand, the maximum load will be beared on the right hand. Now this is the problem with this shovel, and they have came up with a novel shovel with a wheel. See, this is a simple solution. The problem with that shovel is being solved with the help of a simple solution. A wheel is being attached. Now how it make comfort for me to use? I can have both my hands on the handle. I can just move from one place to another place. I can lift the weight. I can move from one place to another place with the help of the wheel. I can drop the weight. Now this is a simple solution. This simple solution is being granted with patent in US, and the US patent number is there. Now this is, so that's why I have told early, you need not to be a person with a science background or whatever it may be. If you have any novel solution to address the societal problem, then every individual can have a patent right. And obviously if we have the provision for the same, we can go for commercialization also. So with this understanding, we'll go for this patent into a deep understanding. So next slide. So as I told you earlier, patent is granted for both tangible as well as intangible assets. So probably most of us will be watching cricket. So the first GIF which I have shown here, it is called as ball tracking. It is called as Hawkeye technology. So this Hawkeye technology is meant for improving the leg before wicket decision in cricket. See, this technology doesn't have any tangible form. Being a user, if I want to use or if I want to feel the technology, I need the help of a monitor or a system. Now it is an example for an intangible property, and that is being granted with patent. And similarly, you consider the bottom, the stump is called as, commercially we used to call as, or conventionally we used to call as an LED stump. And this LED stump, it is being granted with patent, which can be touched and felt. So both a tangible asset as well as an intangible assets, it is being granted with patent. So patent, once again I am repeating, it is meant for invention and innovation. And that invention can be either a product or a process. And that product can be in either form, either a tangible form or an intangible form. The next slide. See, for getting your invention to be granted with patent, so the government of India through the Patent Office and through the Patents Act 1970, they are confining your invention to satisfy 3 criteria. And that 3 criteria are, next slide sir. One is novelty, the second one is inventive step, and third one is industrial applicability. So if your invention is going to satisfy these 3 criteria, obviously your invention can be granted with a patent. So we just understand what all those 3 criteria is about, and before that I would like to just give a small information. So now this is the person, so next. This is the person who actually invented this LED stump, sir. So the history of this LED stump is that the inventor name is Braun Eckermann, and he is an Australian engineer. So what he did is that in the year 2011, he applied for patent to this LED stump in more than 110 countries across the world. And in 2013, he got the grant for this invention, and from 2015, he got, that is in 2015, ICC started to use this LED stump in the major tournaments. See, this LED stump is just a stick with the technology. Now what the actually feature of this LED stump is that during cricket, while playing cricket, the stumping and run out, there will be certain lag in accuracy. To improve the accuracy, he introduced this stump called LED stump. So what is this actually the stump does is that when the bails, that is at the top, when the bails are going off from the stump, this LED light will be glowing. Now the accuracy of this LED glowing is that 1 by 1 lakh per second. So that is what being claimed by Ron Eckermann. Now this 1 by 1 lakh second of accuracy improves the accuracy in decision making. So that is what the benefit of this LED stump in cricket. Now what would be the price of this LED stump, sir? எவ்வளோ விலை இருக்கும்? நீங்கள் வெளியில் போய் ஒரு உட்டன் ஸ்டம்ப் நம்ம வாங்குறோம் அப்படின்னா அதோட ப்ரைஸ் அப்படிங்கிறது ஒரு 3 ஸ்டிக்கு அல்லது இந்த பக்கம் ஒரு 3 ஸ்டிக்கு, ஸ்ட்ரைக்கர் நான் ஸ்ட்ரைக்கர் ஒரு 6 ஸ்டிக்கு வாங்கினோம் அப்படின்னா அதிகபட்சம் ஒரு 2000 ரூபாய்க்குள்ள நம்ம வாங்கிடலாம் ஒரு உட்டன் ஸ்டிக்கு. இதோட ப்ரைஸ் எவ்வளோ இருக்கும்? Almost close. Sir told 10 lakhs. The actual price is approximately 12 lakh rupees. 12 லட்சம் ரூபா ஒரு LED ஸ்டம்ப். சார் நெக்ஸ்ட் ஸ்லைட் போங்க. இப்போ ரீசெண்டாக எல்லாரும் IPL மேபி பார்ப்பீங்கன்னு நினைக்கிறேன். This was the match happened between Punjab Kings and Mumbai Indians on 22nd if I'm right. So 22nd அந்த லாஸ்ட் ஓவர் இவர் பவுல் பண்ணும்போது நெக்ஸ்ட் கன்சிக்யூட்டிவ் பால்ஸ்ல 2 தடவை அந்த LED ஸ்டம்பை உடைச்சாரு and that became the flash news in the next day newspaper. The cost of LED stump which I had broken 24 lakhs. 24 லட்சம் ரூபாய் பார்த்தீங்க அப்படின்னா இவர் உடைச்சிட்டாரு. See, that is the price of LED stump. With the help of one invention, Ron Eckermann have become a billionaire. That is the beauty of intellectual property, right? So if we have an IP asset, obviously we can commercialize it, and throughout our lifetime, so we will be getting a settle. So the tenure or the duration for this patent is 20 years, sir. So if I'm going to file a patent today on 2nd May 2023, and if I'm getting the grant by the year 2026, means this grant will be valid till 2043. That is from the date of filing. From today's date till 20 years I'll be getting the grant of this patent. So that is what the tenure of patent is about. Now we have an understanding about the various criteria for which this IP is going to be, the patent is going to be granted. So next slide. The first one is novelty. So what actually novelty mean is that novelty is nothing but it should be new. New in the sense புதுசா நான் கண்டுபிடிக்கணுமா அப்படின்ட்டு ஒரு கேள்வி வர வேணாம். It is not so. You can just shift the application. Now I have shown here an example. See this gem clip. In the gem clip, what a purpose is, sir? What is the purpose of this gem clip? To hold a bunch of paper. So before this gem clip have came, how we used to hold the bunch of paper? With the help of ஒரு thread, இல்லையா? ஒரு threadல we used to pierce the paper and we used to tie the paper so that we can hold a bunch of paper. Now what actually the problem with this thread is that ஒரு டே போக என்ன ஆகும் அப்படின்னா the paper will be getting torn away, இல்லையா? So that is the problem. To overcome that problem, the inventors have came with this novel clip called gem clip. What actually a gem clip is? It is just a straight string, and the string has been bent in both the directions to 180 degree in opposite way. Now that have become a novel idea. Now this is what called as a novel. Now still, what is the problem with the gem clip is that you cannot hold large bunch of paper. If you try to hold and if you're going to turn the paper, means obviously this gem clip will be coming out of the bunch of paper. To overcome that, they introduced a new form of clip called binder clip. Sir, have you ever seen the mechanism of this binder clip is being used in any of application in our home, sir? நம்ம வீட்ல எங்கயாச்சும் பார்த்திருக்கோமா இந்த பைண்டர் கிளிப்ல யூஸ் பண்ணக்கூடிய அதே மெக்கானிசம் நம்ம வீட்ல எங்கயாச்சும் பார்த்திருக்கோமா? துணிக்காய போற கிளிப் அவ்வளவுதான். Now the application have been changed. Now that is considered to be novel. அவ்வளவுதான். Novelty அப்படிங்கிறது புதுமையா இருக்கணும் அப்படின்ட்டு அந்த பேட்டன்ட் ஆக்ட் சொல்லும். புதுமை அப்படிங்கிறது முழுக்க நீங்க புதுசா கொடுக்கணும்னு அவசியம் இல்லை. You can just shift the application. So ஏற்கனவே ஒரு அப்ளிகேஷன்ல இருக்கக்கூடிய ஒரு டெக்னாலஜியை you can apply to a different technology, sorry, different application, then that can be considered as novel. And next one is sir, inventive step. So what actually an inventive step is that patent actல என்ன சொல்றாங்கன்னா that inventive step should be either it should have a technical advancement or economic significance. So technical advancement in the sense, for example, you consider the same gem clip, sir. Now what is the problem? Another problem with the gem clip is that when day to day it goes, it started to get rusted. So So upon the rust overcome பண்றதுக்கு naturally what we'll be doing, we'll be going for painting. So if I'm being a manufacturer of a gem clip and I'm going to introduce a new form of gem clip which is being painted, means now if I'm going to apply a patent application for this, means the patent office won't be considering this because it is a known concept. So if a particular component is getting rusted, means if it is going to be painted, we can prevent rusting. So it is a known concept. There is no any technical advancement or economic significance. In that way, it will be getting declined. So to get satisfied with the second criteria, your invention should have either technical advancement or either it should have an economic significance. So I have already told what is an economic significance means. So if the price of this podium is 10,000 rupees, means if I have brought a novel process through which the price is brought down to 5,000 rupees or 6,000 rupees, means then that can be considered as an economic significance. So the second criteria to be granted with the patent is inventive step. Now the third criteria is industrial applicability, sir. Next slide, sir. So what is actually industrial applicability means? The invention that you are proposing or the idea that you are proposing, it should be able to be manufactured in an industry, or an industry should be capable of using your idea. So that is the third criteria. அதாவது நீங்க சொல்றத ஒரு இன்வென்ஷன் அப்படிங்கிறது ஐடியாங்கிறது என்ன சார், ஒரு இன்டான்ஜிபிள்ல இருக்கும். அதை நீங்க என்னவா பண்ணணும், ஒரு இன்வென்ஷனா டான்ஜிபிள் ஃபார்முக்கு நீங்க கன்வெர்ட் பண்ணணும். அது கன்வெர்ட் பண்ண முடியாம நீங்க ஒரு illusionல ஏதாச்சும் சொன்னீங்க அப்படின்னா those illusions cannot be granted with a patent. So that is why they have brought a third criteria called industrial applicability. Either your idea should be manufactured in an industry or it should be utilized in an industry. So if your invention is going to satisfy these three criteria, obviously your invention can be granted with a patent. So that are all the three criteria related to patent is concerned. So next slide, sir. So to conclude with patent in India is granted for inventions or innovations, and that invention can be either in a tangible way or an intangible way, and as well as it can be either a product or a process. So in India, patent is granted even for a single article or for assembly of components. So it can be a single article or an assembly of components. Next slide, sir. Or even it can be a part of a composition of matter. For example, we used to have this advertisement saying, so next slide, sir. Nippon. So Nippon used to claim their next slide, sir. Nippon used to claim their paint to be having the technology. கொஞ்சம் முன்னாடி சார். Okay, fine. So Nippon என்ன சொல்வாங்க அப்படினா அவங்களோட டெக்னாலஜி என்ன சொல்வாங்க அப்படினா it is having a lamination technology, and Asian paints என்ன சொல்வாங்க அப்படினா it is an antibacterial technology. So whatever the technology they are bringing in, so ultimately the resemblance or the appearance of the paint is going to be same, but how that paint is having that technology by means of certain composition. So you are cooking a food, that food is having a taste on day 1, on day 2 you have changed the taste, the appearance is going to be same, but how you are able to change the taste of that food by means of composition. So that composition of matter can also be patented in India. And to conclude with patent, so next slide, sir. 90% of patents that are being granted across the world is only given for improvements to an existing invention. ஏற்கனவே இருக்கக்கூடிய இன்வென்ஷன்ல இருக்கக்கூடிய ப்ராப்ளமை ஓவர் கம் பண்றதுக்கு ஒரு சிம்பிளர் சொல்யூஷனா இருந்ததுன்னா அதுக்கு தான் 90% of the patent has been granted. Just a simple example here, you can see maybe பார்த்திருப்பீங்களான்னு தெரியல. This is what happened around 5 to 6 years back, if I'm right. The name of the player is Bill Hughes. He is an Australian cricketer. What happened to him is that while playing a local match, he was trying to play a full shot for a short ball. So kutti bounce on a ball, he tried to play a full shot, but he completely misjudged the ball. So and the full shot ஆட ட்ரை பண்ணும்போது அவரோட பின் பகுதி பார்த்தோம்னா அந்த பாலுக்கு எக்ஸ்போஸ் ஆயிடுச்சு, and what happened is that ball வந்து அவரோட காலோட பின் பக்கத்துல இடிச்சது. So that is what you can see in the gif. So within few minutes he got collapsed and he died. So இப்போ அவர் இல்ல, he is no more. Now this is the problem. இதுல ப்ராப்ளம் என்ன? You can see his helmet. His helmet is having a protection up to the ear. So அதுக்கு பின்னாடி இருக்கக்கூடிய போர்ஷன்ஸ்ல வந்து பார்த்தோம் அப்படின்னா there is no protection, and that's where the new form of helmet came. So next slide, sir. A helmet with a provision to protect your the portion behind your ears. So it was introduced by Missouri Group, and now they are going for IP protection. See, அவ்வளவுதான். ஒரு சின்ன ப்ராப்ளம், அந்த ப்ராப்ளமை ஓவர் கம் பண்றதுக்கு ஒரு சின்ன சொல்யூஷன். ஸோ the thing what we have to do is that we just want to identify what is the problem that is coming around us. So நம்மளை சுற்றி இருக்கக்கூடிய ப்ராப்ளம் என்ன அப்படிங்கிறத நம்ம தெரிஞ்சுக்கிட்டோம் அப்படின்னா obviously if we are able to identify the problem we can give a solution. Now the problem is with most of us is that we have the problem to identify a problem. அப்படிதானே, இது என்ன ப்ராப்ளம் நம்ம சுற்றி இருக்குன்னு தெரிஞ்சுக்கிறது தான் நம்மளுடைய பெரும்பாலான ப்ராப்ளமாக இருக்குது. So if we are able to identify a problem, obviously we can give a solution for the problem. இல்லையா, இப்போ நம்மளை சுற்றியே இந்த ஹாலில் எக்கச்சக்கமான ப்ராப்ளம் இருக்கு, ஆனால் அந்த ப்ராப்ளம் நம்மளால கண்டுபிடிக்க முடியாது இல்லையா. So that is a problem with us. So if we are able to identify a problem, obviously we can give a solution for the problem, and that can become a patentable one. So that is what patent is concerned. So if you have any illusion or a misconception that patent is only meant for greater inventions, we just remove it from our mindset, because even simpler solutions can also be granted with a patent. So you need not to have a science background or engineering background or medical background. No, you need not to have all those steps. What you have to do is that an open-minded to identify a problem, and a novel creativity mindset with the creativity to give a solution for the problem. So that is what it is required. So if we are able to give that, obviously we can give gain a IP right, that is in a form of patent. So that is all what patent is concerned. Now we'll have a quick glance on other forms of IPs. The next slide. The next type of IP is called as copyright. In the C with the circle, நம்ம நிறைய இடத்துல பார்த்திருப்போம் இல்லையா சார். Being a faculty member, we would have seen in the textbook. அந்த பப்ளிஷரோட நேமுக்கு மேலே பார்த்தோம் அப்படின்னா C போட்டு சர்க்கிள் போட்டுட்டு copyright is reserved with so and so publisher. In a similar way, during end of a program, we used to see that C with the circle. So copyright is reserved with so and so network. யூடியூப் சேனல்ஸ்ல நம்மளால பார்க்க முடியும். நீங்க கூகுள்ல இமேஜஸ் சர்ச் பண்றீங்கன்னா அந்த Cங்கிற சிம்பிள் பார்க்க முடியும். So in India, this copyright is meant for creations. So and tenure for protecting the copyright is after 60, that is after death of the creator, 60 years வரைக்கும் இது லைவா இருக்கும். That is, if I have created a work and if I have gotten a copyright, if I have got a copyright for that same அப்படின்னா என்னுடைய இறப்புக்கு பிறகு 60 ஆண்டுகள் அந்த காப்பிரைட் லைவ்ல இருக்கும். அப்ப என் இறப்புக்கு அப்புறம் அது யார்கிட்ட இருக்கும்? என் tangible asset யாருக்கு போகுமோ அதே மாதிரி தான் இதுவும் போகும். So after my death, so what is the provision for my tangible asset? In a similar way, the legal heir can avail with the benefit of this copyright. So that is what this copyright is meant for. After copywriting is the next step. So it is meant for creations, and the creation can be in any of these forms. It can be a literary work, sound recording, ஒரு டிராமாவா இருக்கலாம், ஒரு ஆர்ட்டா இருக்கலாம், மியூசிக்கல் ஒர்க்கா இருக்கலாம், சினிமாட்டோகிராஃபியா இருக்கலாம். மேபி இதுல எத்தனை பேர் இந்த பொன்னியின் செல்வனோட ஃபர்ஸ்ட் பார்ட்டோட ஆடியோ லான்ச் பார்த்துருப்பீங்கன்னு நினைக்கிறேன். கமல் சார் வந்து பேசும்போது பார்த்தோம் அப்படின்னா இந்த காப்பிரைட்டை பற்றி பேசியிருப்பாரு. ஸோ ஆக்சுவலி ஹி காட் த காப்பிரைட். யார்கிட்ட நினைக்கிறேன்னா இப்போ ஐம் ரைட் எம்ஜிஆர் சார்கிட்ட அந்த காப்பிரைட் வாங்கியிருந்த மாதிரி எனக்கு ஞாபகம், அப்படி சொன்ன மாதிரி ஞாபகம். அதுக்கடுத்து நவ் இட் இஸ் ஓப்பன் டு ஆல், பிகாஸ் இதோட கிரியேட்டர் யாரு? கல்கி சார். அண்ட் கல்கியோட இறப்புக்கு அப்புறம் பார்த்தோம் அப்படின்னா நவ் இட் இஸ் ஓப்பன் டு ஆல். ஸோ அப்போ that is what this copyright is meant for. So அப்போ copyright அப்படிங்கிறது it can be for any form of creations, and that creation can be in any of these forms. It is not only restricted to this, it can be in any of the forms, and this creation can be even a compilation of works. So for example, the next slide போங்களேன். For different expression of thoughts, for example, Jungle Book, everyone would have came across the story of Jungle Book. But Jungle Book came in different formats. So a cartoon, it came as a movie, it came as an animated film, it came as a book, it came as a comic. It had its different forms. Every different expression of thought is protected under copyright. But the storyline is same here. Story ஒன்று தான், ஆனால் அதை கிரியேட் பண்ண கிரியேட்டர் they have expressed in different way of expression, and those expression of thought can also be protected under copyright. ஸோ இப்போ நான் ஒரு ப்ரெசன்டேஷனை ப்ரெசென்ட் பண்ணியிருக்கேன். இதை நீங்கள் வேற ஒரு டெம்ப்ளேட்ல அல்லது வேற ஒரு ஃபார்மேட்ல இஃப் யூ ஆர் ஏபிள் டு ப்ரெசென்ட் அப்படின்னா that presentation can also be protected under copyright, provided I need to acknowledge the original creator. And that is why throughout my presentation slide you can see this source. So where I have to from. சரியா, next slide போங்களேன் சார். As I told earlier, compilation of work can also be copyrighted. The presentation which I am presenting now, it has been copyrighted. So இதுல இன்ஃபர்மேஷன்ங்கிறது ஒன்றும் புதுசாலாம் இல்லை சார். I have collected the information from various sources, I have compiled it, and I have presented in a way the user or the end user wants. So அப்போ எங்கெங்கெல்லாம் இன்ஃபர்மேஷன்ஸை கலெக்ட் பண்ணேனோ I have acknowledged the source then and there, With the help of that, and the content we have applied for copyright, and you can see it has been granted or registered under copyright. So upon the copyright kind of certificate and on the presentation slides, over pages deputy register of copyright or on the signature and key acknowledgement slip. So if you feel that patent அப்படிங்கிறது challenging I need some time to get a patent one of the simplest form of IP is copyright. Because being an academician, we would have developed our academic works. So our academic works compile we would have developed, and every one of us can protect our academic work under copyright, provided we are acknowledging the original creator and acknowledging the original source from where we have took the information. So our presentation content or the students notes of lesson whatever it may be. So if you are acknowledging it in the right way and நீங்க அத ஒரு better way ல present பண்றீங்க அப்படினா then that can be protected under copyright. And copyright concern பொறுத்த வரைக்கும், as I told you earlier, so copyright is meant for 60 years after death of the creator. So that is what copyright is concerned about. So next one, we'll go to the next form of IP, that is trade secret. So இப்போ almost இங்க எல்லாருமே வந்து கோக் நம்ம டேஸ்ட் பண்ணிருப்போம்ல சார். So have you ever felt the change in taste of Coke when first time நீங்க டேஸ்ட் பண்ணதுக்கும் ரீசன்ட்டா நீங்க டேஸ்ட் பண்ணதுக்கும் நம்ம ஃபீல் பண்ணிருக்கோமா? Mostly not, இல்லையா? And if I'm going to drink a Coke from one shop and நான் ஏதோ ஒரு 1000 கிலோமீட்டர் தள்ளி இன்னொரு இடத்துல போய் நான் ஒரு Coke டேஸ்ட் பண்ண போறேன் அப்படினா obviously the taste is going to resemble. Now in a business, if I feel that any of the information or any of the stuff it is going to help me in getting a market advantage over my competitor means, then those stuff can be protected under trade secret. It need not to be a drink or a composition, even it can be a data. So if I'm running a data analysis company and if I feel that the data of my customer is my asset, then I can protect the data of my asset the data of my customer as a trade secret. So in that way, if you feel any of the information or any of the stuff related to your business gives you the market advantage over the competitor means, then those stuffs can be protected under trade secrets. So as like Coke is concerned, so they are in the market for more than 120 years. Still they are dominating the entire cold drink market. So next slide. And just for our information, this Coke formula was actually developed by a person called Johannes Pemberton, and during his due course of life, he completely transferred the license to a company which later got formed as a Coke. So since they have protected it under trade secret, they are able to sustain in the market for 120 years. And in fact, it has been said that they are investing a lot to protect that Coke formula. So next slide. The Coke formula, they are claiming it to be protected in a place called Coke World Museum. So it is located in California, and it is being maintained as a high technology vault within which the Coke formula is being protected. And it is also being said that enna solranga appadina only 2% in the world knows about this trade secret of Coke formula, and அந்த ரெண்டு பேர் யாருன்னு அந்த ரெண்டு பேருக்கு தெரியாதுன்னு சொல்றாங்க. And அந்த ரெண்டு பேரோட டிராவல் பிளானை பார்த்தோம் அப்படின்னா கோக் தான் டிசைட் பண்றாங்கன்னு சொல்றாங்க. இதை ஏன் நான் சொல்றாங்கன்னு சொல்றேன்னா அதையுமே அவங்க சீக்ரெட்டா தான் வச்சிருக்காங்க. So just based on collecting information from various sites, I am just presuming that it could have been done in that way. So that is what the secrecy is. So trade secret பொறுத்த வரைக்கும் there is no any tenure for protecting your trade secret until otherwise your secret is being revealed. Then அது வரைக்கும் நீங்க என்ன பண்ணலாம்னா உங்க ட்ரேட் சீக்ரெட்டை ப்ரொடெக்ட் பண்ணிக்கிட்டே இருக்கலாம். பிகாஸ் கோக்கோட டேஸ்ட்டை வேற யாருமே என்ன ரிசம்பிள் பண்ணல. சிமிலர்லி மற்ற குளிர்பானங்களா இருக்கணும். இப்போ இதே நம்ம ஒரு ரூரல் சைட் போறோம் அப்படின்னா we used to have tasted a drink, right? So அதே டேஸ்ட்டை இன்னொரு பிராண்டும் பார்த்தோம் அப்படின்னா a similar taste will be there because their trade secret would have been revealed by the competitor. So until you are able to protect your secret, it will be in life. So when someone else revealed your secret, then the trade secret will be getting expired. So next slide, sir. So it is not only meant for ஒரு food based product மட்டும் கிடையாது. Even Google is not the only search engine in the world. There are a lot other search engines. But why we used to prefer Google means it is giving most accurate results. See, for example, if I am going to search Anna Nagar in Rajapalayam means என் லொகேஷனை சர்ச் பண்ணி ராஜபாளையம் இருக்கக்கூடிய அண்ணா நகர் தான் அது காட்டும். If I am going to stand in Madurai and search Anna Nagar means it will be showing the result of Anna Nagar in Madurai. So that is the accuracy. and that accuracy is only by means of the program they are having in the behind the screen, and they are maintaining it as a trade secret. Similarly, KFC chicken, so it is having lot of outlets. Wherever you go, you will be having the same taste. And similarly, Madurai is famous for Jigadanda. So one particular shop is having that unique taste, and that is not able to be reflected or replicated by another competitors because they are making it to be secret. So that is what trade secret is about. And next type of IP is next slide, sir. Trademark. So what actually a trademark is that it helps the consumer to distinguish who is the manufacturer. Because road la or car போது அந்த கார் எந்த கம்பெனியோடதுன்னு நம்ம எப்படி கண்டுபிடிக்கலாம் சார்? Logo. So that logo helps me to identify who is the manufacturer. In a similar way, if there are any steps which helps you to identify as a consumer who is the original creator or who is the competitor name means, then those steps can be protected under trademark. It can be in any form. It can be a smell or a sound, brand, signature, logo. Even you can see the signature of Tendulkar is being protected under trademark because Mumbai இருக்கக்கூடிய Tendulkar's அப்படிங்கிற ஹோட்டலோட நேம் our signature form represent பண்ணிருப்பாரு, and that is being protected under trademark. So it can be in any of this form. So any steps which helps the consumer to identify or classify the goods and those goods manufactured by whom, then those steps can be protected under trademark. So trademark oda protection பொறுத்த வரைக்கும் இந்தியால 10 years it can be protected, and after that it can be renewed every 5 years. Next slide, sir. அப்போ ட்ரேட்மார்க்கோட இம்பார்ட்டன்ஸ் என்ன, அதோட முக்கியத்துவம் என்ன அப்படிங்கிறத பார்ப்போம் சார். அதுக்கு முன்னாடி ஜஸ்ட் a small information. If you are going to market, hereafter if you haven't noticed, hereafter you just try to notice this. You can see two of this mark in a product, brand name or the logo. One is TM or R with a circle. So what is the difference between these two is that if there is to be represented in the form of TM means the company have applied for trademark and it is to be granted. And if it is represented as R in a circle, it is being applied and it is being granted. If there is no any mark, they haven't applied. See? So that is what the difference between a TM, R and no mark. Next one, sir. So we just understand the importance of the trademark. So how it is going to bring a value to a company. Now what I just want to do is that I show an image here. You just tell what is the name of the product. Name of the product. Next slide. வனஸ்பதி. ஆனால் கடையில் போய் என்ன கேட்போம் நம்ம? கடையில் போய் டால்டான்னு கேட்டால் அவர் எது கொடுப்பாரு? இந்த மஞ்சள் பாக்கெட்டை தான் கொடுப்பாரு இல்லையா? வனஸ்பதின்னு கேட்டால் தான் என்ன பிராண்ட் வேணுன்ற கொஸ்டின் வரும். ஸோ நவ் ஹியர் as the name of the product name of the brand overtook the product name, that becomes the advantage for this company because they have protected it under trademark and the trademark name have got registered in the consumer mind. Next, sir. What about this? Next. What about this? Actual name is diaper, but we used to call it as pampers. So கடையில் போய் நான் pampers வேணும்னு கேட்டால் கடைக்காரர் என்ன சைஸில் வேணும்னு கேட்பார். ஸ்மாலாக, மீடியமாக, லார்ஜாக, எக்ஸலா அப்படின்னு கேட்பார். நான் கடையில் போய் டயப்பர் கொடுங்கன்னா தான் அவர்கிட்ட என்ன கேள்வி வரும்? pampers வேணுமா, ஹக்கீஸ் வேணுமா, மேமி போக்கோ பேண்ட்ஸ் வேணுமா, இந்த கேள்வியே வரும். So now that is the value of trademark. So if you are able to protect your trademark and if that becomes if that gets registered in the consumer's mind, then a day or other your brand name will overtake the product name. Next slide, sir. Next. What about this product? This machine? But the actual name is backhoe loader. JCB is one of the company which manufactures this backhoe loader. What about this? Next slide, sir. Is that a machine? Photocopier. The actual name is photocopier. Xerox is one of the company which manufactures this photocopier. So for recent days la Xerox அப்படிங்கிற ஒரு ப்ராடக்ட்டை நம்மளால பார்க்க முடியாது. It has been replaced with HP or Canon. அதுதான் வந்துச்சு. So இப்போ நான் ஒரு photocopier கடைக்குள்ள போறேன் அப்படின்னா உள்ள இருக்கிற மெஷின் either it will be in HP or Canon. ஆனா வெளியில வந்து கடை பேரை பார்த்தேன்னா Xerox கடை. See, even the company have expired, the brand name still lives in the market, in the mindset of the consumer. That is the value of trademark. அப்போ ட்ரேட்மார்க்கோட இன்னும் முக்கியத்துவம் என்ன அப்படிங்கறத ஒரு statistical dataவோட பார்ப்போம் சார். Next slide. See, we all know that Flipkart is an e-commerce site and now almost 81% of the shares of Flipkart is being procured by Walmart இல்லையா? ஸோ வால்மார்ட் அப்படிங்கிற நிறுவனம் அதோட 81% பங்குகளை வந்து பார்த்தோம் அப்படின்னா வாங்கிட்டாங்க. So in the year 2018-19, it has been reported that Flipkart is a company which faced almost 3,800 crores of loss. In spite of being a company which faced 3,800 crores of loss, Walmart, they procured around 77% of shares of Flipkart for a price of 16 billion US dollar. 3800 கோடி நஷ்டத்துல இயங்கின ஒரு நிறுவனத்தோட 77% பங்குகளை 16 பில்லியன் US டாலர் கொடுத்து ஒரு பெருநிறுவனம் வாங்கியிருக்கு. என்ன ரீசன்? valuation of the company. And the valuation of company ல ஒரு vital role எது play பண்ண போகுதுன்னா trademark. So if any of you are a student or even நீங்க ஒரு business start பண்ண போறீங்க அப்படின்னா after registering the company you just get an you just advise your student or நீங்க பண்ண போறீங்க அப்படின்னா you just right away go to registering the trademark because நம்ம யூசுவலா சொல்லுவோம் சார் ஒரு யாரோ ஒருத்தங்க ஒரு வழிபோக்கர் வராரு ஒரு அட்ரஸ் கேட்கிறாரு அப்படின்னா நம்ம ஒரு லேண்ட்மார்க் சொல்லுவோம்ல அந்த லேண்ட்மார்க் எப்படி ரெஜிஸ்டர் ஆயிருக்கு அந்த வேல்யூ and அந்த வேல்யூவேஷனுக்கு one of the அந்த reach என்ன அப்படின்னா one of the stepstone என்ன அப்படின்னா trademark. So next slide. So that is all about trademark. Now we'll move on to the next form of IP, that is industrial design or design registration. See, I have wear a shirt. இந்த ஷர்ட்ல ஒரு டிசைன் இருக்குது, it can be protected under industrial design. நான் கடையில போய் ஒரு saree வாங்க போறேன், அந்த சாரியில ஒரு யூனிக்கான ஒரு டிசைன் இருக்குது அப்படின்னா that can be protected under industrial design. நம்ம நகை வாங்க போறோம்னா பிரைமரியா என்ன பார்ப்போம்? apart from price, நகையோட design. If it is having a unique design, it can be protected under industrial design. So the aesthetic appearance of a product is meant for industrial design. If I want to protect the aesthetic appearance of a product means then those stuff can be protected under industrial design in India. And you can see in the Fanta bottle and the label இல்லாட்டினால அது Fanta bottle என்னால கண்டுபிடிக்க முடியும். ஏன்னா என் மைண்ட்ல ஃபிக்ஸ் ஆயிருக்கு அந்த பாட்டிலோட ஷேப் இப்படி இருந்தா அது Fanta. So next slide. Next one time. இது என்ன ப்ராடக்ட்? நான் எப்படி கண்டுபிடிக்க முடியுது இதுல இருக்காங்க? The shape of the bottle இல்லையா? Now it can be protected under industrial design. So next slide. So ஒரு unique appearance and aesthetic appearance இருந்தது அப்படின்னா that can be protected under industrial design. Next slide sir. Now we'll understand what is the importance of this industrial design, how far the consumer is getting understood about industrial design. Next slide sir. இது என்ன brand pencil sir? தெரியல. So actually it is a pencil which will be in Camel ஓட geometry boxல இருக்கும் இந்த pencil. So next slide. இது so எப்படி நம்மளால கண்டுபிடிக்க முடியுது? The color combination இல்லையா? So that is what the industrial design is meant for. So அப்போ நம்ம யூசுவலா நம்ம ஸ்டூடண்ட்ஸ்க்கு என்ன பழக்கம் இருக்கும் அப்படின்னா யுனிவர்சிட்டி எக்ஸாம் அன்னைக்கு காலையில அவசரமா ஒரு ப்ராடக்ட் வாங்கிட்டு போவான், பென், பேப்பர், பென்சில் எல்லாத்தையும் வாங்கிட்டு போவான். கடையில ஸ்டேஷனரியில இருக்குன்னா தூரத்துல ரெட் கலர்ல ஒரு பாடியில பிளாக் ஸ்ட்ரைப்ஸ் இருக்குது, அதை நட்ராஜன் நினைச்சு அவசரத்தை என்ன பண்ணிட்டு போயிடுவான், வாங்கிட்டு போயிடுவான். ஆனா அங்க போய் சீவனதுக்கு அப்புறம் தான் தெரியும் அது உடஞ்சுக்கிட்டே இருக்கும். அப்ப அது என்ன நட்ராஜன். அப்போ அந்த காம்படிட்டர் என்ன பண்ணிட்டாங்க, they took advantage of this IP asset of Natraj. So if Natraj doesn't want any of its competitor to make use of this IP asset means they can protect it under industrial design. So next slide. What about this pen? பெரும்பாலும் தெரியாது. Next slide. Renault 045. So if a pen with a body on white color and with a cap in blue color means obviously நம்ம மைண்ட்ல ரெஜிஸ்டர் ஆயிருக்கு, it is Renault 045. So that is the value of என்ன அப்படின்னா industrial design. The next slide. The industrial design பொறுத்த வரைக்கும் பாத்தீங்கன்னா டோட்டலா you can protect it for 15 years. So as far as patent is concerned 20 years. Similarly industrial design can be protected for 15 years. So next slide. Yes. So new and plant variety protection. So plant variety protection அப்படிங்கிறது if any of the inventor is coming up with an invention which is related to plant kingdom means those stuffs can be protected under plant variety and farmers right protection. And in India it is being granted for a period of 10 years or 15 years based on the nature of the plant. அது plant இருந்ததுன்னா if I write 10 years and tree related இருக்குது அப்படின்னா 15 years. The next slide sir. So for example you can see this cotton plant. So this cotton plant is having a problem of getting affected by this bollworm. So what does this company Monsanto did is that they came up with a novel seed which is usually called as a BT. So BT cotton நம்ம சொல்லுவோம் இல்லையா, BT cotton, BT கத்திரிக்காய் நம்ம சொல்லுவோம் இல்லையா. So it is being genetically transformed seed and they have developed a genetically transformed seed from which if a plant is growing means it won't be getting affected by this bollworm. So they have made some transformation genetically and those stuff can be protected under plant variety and farmers right protection in India. So next slide. And the next form of IP is geographical indication. அதுக்கு முன்னாடி இந்த SIC எழுதி என்னன்னு சொல்லியிருந்தேன். நம்ம மொபைல் ஃபோனில் உள்ள திறந்து பார்த்தோம்னா ஒரு IC ஒரு சர்க்யூட் இருக்கும் இல்லையா, அந்த ஐசி சர்க்யூட்ஸோட டிசைனை ப்ரொடெக்ட் பண்ணுறது தான் என்ன அப்படின்னா இட் இஸ் SICLDR, செமிகண்டக்டர் அண்ட் இன்டகிரேட்டட் சர்க்யூட் லேஅவுட் ரெஜிஸ்ட்ரி டிசைன் ப்ரொடெக்ஷன் அப்படின்ட்டு நம்மகிட்ட இருக்குது. பட் ஆஸ் ஃபார் அஸ் இந்தியா இஸ் கன்சர்ன்ட் we haven't got explored much on this SICLDR, so that is why 2001 அதை introduce பண்ணாங்க. till date la just 2 SICLDR grant have been granted. So one is given for Bharat Electronic Limited and other one is given for ISRO, Indian Space Research Organization. And the last form of IP is geographical indication. So நம்ம ஸ்ரீவிக்கு ஃபேமஸ் எது சார்? பால்கோவா. திருநெல்வேலினா மதுரைனா அப்போ ஒரு ஊர் சார்ந்த ஒரு ப்ராடக்ட் வருது இல்லையா, அது எல்லாத்தையும் எதில் ப்ரொடெக்ட் பண்ணலாம்னா geographical indication நம்ம protect பண்ணிக்கலாம். So next slide sir. So as far as geographical indication is concerned, ஒரே ஒரு exemption when compared with other forms of IP. Other forms of IP can be given for an individual or for an individual organization, whereas geographical indication will be given only for a community or an association. You should be a registered society. அந்த சொசைட்டிக்கு மட்டும் தான் பாத்தீங்க அப்படின்னா அந்த grant அப்படிங்கிறது கொடுப்பாங்க. That is GI grant அப்படிங்கிறது கொடுப்பாங்க. Next year sir. And GI tenure பார்த்தோம் அப்படின்னா it is going to be for 10 years. So 10 years அப்புறம் நீங்க என்ன பண்ணலாம்னா renew பண்ணிட்டே போலாம். சரிங்களா? Next sir. So GI will be covering these 4 commodities. So either it can be an agricultural product or it can be a manufactured commodities, handcraft work அல்லது natural and foodstuffs. So these stuffs can be protected under geographical indication. So next slide sir. So as far as India is concerned, the geographical indication was granted for Darjeeling tea in the year 2004. Next slide sir. And Tamil Nadu concerned பொறுத்த வரைக்கும் பார்த்தோம் அப்படின்னா the first ever GI was granted for Salem fabric. So for your information, India more than 450 types of GIs have been granted, out of which maximum number of geographical indication it is being granted through Tamil Nadu. So Tamil Nadu is having more than 51, if I am right, exactly 51 geographical indications are being granted for the commodities which originated from Tamil Nadu. And recently March 31st, if I am right, Tamil Nadu சார்ந்த ஒரு 11 பொருட்களுக்கு புவிசார் குறியீடு கொடுக்கப்பட்டது. அது கொடுத்ததுக்கு அப்புறம் தான் பாத்தீங்க அப்படின்னா we have become the state with large number of geographical indication and followed by yaar அப்படின்னா Karnataka. So that is all about geographical indication is concerned. If any of the commodity or the product is having its unique quality with respect to the geographical origin அப்படின்னா then those stuffs can be protected under geographical indication. இப்போ நம்ம ராஜபாளையத்துக்கு சப்பாட்டா மாம்பழம் ஃபேமஸ் அப்படின்னா ராஜபாளையத்தோட மண்ணையும் ராஜபாளையத்தோட கிளைமேட்டிக் கண்டிஷன்ல மட்டும் அந்த யூனிக் டேஸ்ட் இருக்குது அப்படின்னா then that type of mango can be protected under geographical indications. But அதே டேஸ்ட் அதே யூனிக்கான ஏதோ ஒரு ஃபீச்சரை வேற ஒரு லேண்ட்ல கல்டிவேட் பண்ண முடிஞ்சது அப்படின்னா then that cannot be granted with geographical indication. So that is what a GI is about. And if any of your student is getting interested to start a business related to trade அப்படின்னா you just encourage them to start an export business which is related to this GI. ஏன்னா GI டேக்டா இருக்கக்கூடிய கமாடிட்டியை நீங்க எக்ஸ்போர்ட் பண்ணோம் அப்படின்னா அதுக்கான வேல்யூ அப்படிங்கிறது ஜாஸ்தியா இருக்கும் சார். ஸோ தட் ஒரு GI டேக்டு கமாடிட்டியை if a student or if an entrepreneur is going to export அப்படின்னா he will be getting a better market advantage over other traditional products. So that is all what GI is about. The next slide. So அவ்வளவுதான். இதான் 8 different types of IP. And here I put a conclusion here is that so நம்மளோட டியூட்டி அப்படிங்கிறது இங்கேயோட நம்ம ஸ்டாப் ஆகல. So we just want to encourage our own students to protect any kind of IP and in turn we have to be an inspirer to them. So அதனால நம்ம ஏதோ ஒரு டைப் ஆஃப் ஐபியை நம்ம ப்ரொடெக்ட் பண்ணி அதை நம்ம கொஞ்சம் ப்ராக்டிஸ் பண்ணி கொடுக்க ஆரம்பிச்சோம் அப்படின்னா so definitely the student will be getting inspired on us and they will be starting to protect their own types of IP whichever is applicable. So once again I am telling patent அப்படிங்கிறது உங்களுக்கு பெரிய விஷயமா தெரிஞ்சதுன்னா you start with copyright because அது ரொம்ப சிம்பிளரான ஒரு விஷயம் and அதை நம்ம ஸ்டார்ட் பண்ணோம் அப்படின்னா so as we are getting used with that நம்ம ஒரு 4 5 6 காப்பிரைட் வாங்கிட்டோம் அப்படின்னா நமக்கே ஹெல்த் ஒரு போர் அப் ஆயிரும். ஸோ அதுக்கப்புறம் என்ன பண்ணலாம்னா அதர் ஃபார்ம்ஸ் ஆஃப் ஐபியை நேச்சுரல் நம்மளே எக்ஸ்ப்ளோர் பண்ண ஆரம்பிப்போம். ஸோ தட் இஸ் ஆல் அபவுட் டிஃப்ரெண்ட் டைப்ஸ் ஆஃப் ஐபி. ஸோ தேங்க்யூ ஆல் ஒன்ஸ் அகைன் ஃபார் திஸ் வண்டர்ஃபுல் ஆப்பர்ச்சுனிட்டி டு ஷேர். If any queries you can ask her. So because அடுத்த செஷன் ஸ்டார்ட் பண்ணுவோம்.
Sir,
Yes.
the patent is valid for only 20 years.
Yes, sir.
After that, can we renew or
No, sir. We cannot renew, sir. It will be open to the public, so anyone can manufacture that invention and market it. ஏன்னா 20 இயர்ஸ்க்கு மேலே நம்ம கொடுத்தோம் அப்படின்னா அந்த இன்வென்ஷன் வந்து ஒரு மோனோபோலியாக மாறிடும். மோனோபோலியாக மாறும்போது பார்த்தோம் அப்படின்னா நான் அடுத்து என் சந்ததி அதுக்கடுத்து அவங்க மட்டும் தான் அதுக்கான உரிமையை வச்சிருக்கும் போது everyone cannot use it in a wider way. So that is why it has been restricted to 20 years.
So publish பண்ண papers வந்து patent பண்ண முடியாது.
Sir, obviously sir. நம்ம மூணு criteria பார்த்தோம் இல்லையா, novelty, inventive step, industrial applicability. Novelty என்னன்னா புதுமையா இருக்கணும். So புதுமை in the sense it should not be known to anyone else in the world. So அப்போ publication அப்படிங்கிறது is a mode of communicating to the entire world. So அப்போ இதுல patent பொறுத்த வரைக்கும் ஒரு constraint என்ன இருக்குது அப்படின்னா you can have a 12 months period of time. So அதுக்குள்ள if you are able to prove that as far as the academic mandate requirement is concerned, I have published அப்படின்னு உங்களால prove பண்ண முடிஞ்சது அப்படின்னா then that consideration will be considered, sir. So that too for 1 year. 1 yearக்கு மேல அது போச்சு அப்படின்னா obviously we cannot protect that under patent. So நம்மளுடைய அந்த பேப்பரையே ரெஃபர் பண்ணிட்டு நாவல்ட்டி இல்லைன்னு சொல்லிட்டு கிராண்ட் வந்து ரிஜெக்ட் பண்ணுவாங்க.
நாவல்ட்டி சொல்றீங்கல்ல, தென் பேட்டன்ட் அப்ளை பண்ணி நம்ம வாங்கிடுறோம், அதுக்கப்புறம் நம்மளோட சீக்ரெட் வந்து அவங்க பப்ளிக்கு போகுமா இல்லை அதை செக்யூர் பண்ணுவாங்களா?
அதான் மேம், இப்போ எப்படி இருக்கும் அப்படின்னா நான் நாவல்ட்டிலாம் கிளியர் பண்ணி எல்லாத்தையும் கிளியர் பண்ணி பேட்டன் கிராண்ட் வாங்கிட்டேன். இப்போ நான் திஸ் பேட்டன் வில் பி ஓப்பன் டு ஆல் த சென்ஸ் நான் என்ன இன்வென்ட் பண்ணியிருக்கேங்கிறத நான் டிஸ்க்ளோஸ் பண்ணிட்டேன். பட் வாட் இஸ் திஸ் ஐபி ரைட் இஸ் கிவ்ஸ் தட் இந்த 20 இயர்ஸுக்கு வேற யாரும் என்ன பண்ண முடியாதுன்னா என்னுடைய பெர்மிஷன் இல்லாம யூஸ் பண்ண முடியாது. இஃப் தே வாண்ட் டு யூஸ் இட் they need to have a permission from me. So அதுதான் அந்த patent
சீக்ரெட் வந்து எதுவுமே இல்ல, ஓபன்
it will be open to all. It will be open to all as far as patent is concerned.
Computer programs ஐயும் patent பண்ணுவோம்.
Computer programs are meant for copyright, sir. So இந்தியால computer programs copyrightல மட்டும் தான் நம்மளால பண்ண முடியும். When that programs have been integrated or a software is integrated with the hardware அப்படின்னா then that can be protected under patent, sir. So ஒரு ஹார்ட்வேரோட நீங்க இன்டகிரேட் பண்றோம் அப்படின்னா அதை நம்மளால ப்ரொடெக்ட் பண்ண முடியும். அல்லது நீங்க வெறும் ப்ரோக்ராமா மட்டும் இருக்குதுன்னா it will be in a textual form. அந்த textual form we can protect only under copyright, sir. Thank you.
Thank you so much, sir. We are spellbound by your mellifluous flow of speech. Now we are aware of IPR is really the need of the hour. Before your speech, we know that patent and copyright are related only to intellectual property rights. After your speech, we are aware of the 8 types of intellectual property rights. Literally, sir, we are in the trance in the world of IPR. Thank you so much, sir, for your informative session. The next resource person will join us within few seconds through Google Meet.
Good afternoon. Let me wait for some introduction.
So just few seconds to start with the introduction, sir.
Fine, okay.
A smile is always the best form of introduction. Now I would call upon Mrs. Manjula Gayatri, Assistant Professor of Commerce, to introduce the chief guest.
Good afternoon, everyone. It gives me immense pleasure to introduce the chief guest for today's session, Dr. G. Balaganesan. He has done his bachelor's and master's in mechanical engineering and Ph.D. in aerospace engineering department, IIT Madras. He has more than 30 years of experience in the field of manufacturing and teaching. He's also doing active research in the field of impact loading and repair of oil and gas pipelines using advanced composite materials and published 40 international peer-reviewed journal papers. He has presented his research work in more than 30 international conferences. He has filed 8 patents, and some of them are products of startup companies incubated at IIT Madras. He is instrumental in setting up laboratory facilities of new IITs such as IIT Hyderabad in 2008, IIT Palakkad and Tirupati in 2015, and IIT Jammu in 2018. He has served as a faculty member on deputation at the Department of Mechanical Engineering, IIT Jammu, from 2018 to 2020. Dr. Bala has coordinated to offer employability skill training program to engineering diploma engineers of Nagaland and J&K state in 2017, 19, and 22. He has mentored 2 startup companies incubated at IIT Madras. We are happy to have you, sir, online, and we are really expecting you offline also in future.
Thank you, Dr. Mansulat. Thank you for nice introduction. And I'll start my presentation. Shall I open my screen?
Yes, sir.
Aspire to inspire before we expire. Now I will request Dr. G. Balaganesan, Senior Technical Officer from IIT Madras, to address the gathering.
So, good afternoon to all of you. And the topic overview of intellectual property rights. And the topic given in the title is intellectual property rights, need of our country. And you know, the last few weeks before we came to know that India is a highly populated country in the world. So now there is a need of setting up industries and creating job opportunities at every part of the country. And this topic is very much need of our, and even like a place like a Rajapalayam, so it's like an industrial area, and I am also from the same location. So I'm very happy to share my experiences. So I am with IIT Madras since 2005, and I basically my education from the same district, Rajapalayam, nearby area. And I started my journey in industries in 1991, and I worked in private industries till 2004. So 2005 I joined at IIT Madras, and I have trained more than 15,000 BTech students to undergo hands-on training. And also, as Madam told, that I also coordinated to set up facilities to other IITs. So I am sitting in the place where in IIT Madras, initially the Germans were at IIT Madras. So I want to brief about IITs in India. So there are 23 IITs as of now in India, out of which 5 IITs are first generation IITs created between 1950 to 1960. So after independence of India, then our government of India requested some developed countries should set up some IITs in India. So IIT Madras was supported by German. So even Germans were at IIT Madras from 1958 to till 1974. So they were here to create laboratory facilities, to offer courses to the students in the beginning years. And after 50 years, Government of India set up second generation IITs. That in 2008-9 academic year, IIT Hyderabad, IIT Patna, IIT Indore, IIT Gandhinagar, like about 10 more IITs they created in 2008-9, and IIT Madras was mentor institute for second generation IITs, IIT Hyderabad. And in 2015-16, again Government of India created third generation IITs like IIT Tirupati, IIT Palakkad, and IIT Goa, and IIT Jammu. So the objective of our Government of India is to create one IIT in each state. So now after creating these 23 IITs, now that the Government of India has gone for creating IITs in other countries. So there will be one IIT coming up in Middle East, mentored by IIT Delhi, and one IIT is coming up in Africa, mentored by IIT Madras. So now, based on our experiences, so Indians, we are able to create n number of IITs in any part of the world. So that much confidence we have. So with this introduction, just I start about this intellectual property, and this is my objective, to give some fundamentals about technology transfer, intellectual property rights, and also I want to talk about the connection between the academic institution and the industry. So how to make that academic work, academic research can be made as industrial products. So based on my experience, so I want to share my experience during this interaction. So there are topics about IP, intellectual property, patent, industrial design, and some case studies, IPRs and licensing and technology transfers and agreements, and a trademark. So if you look at properties, so basically we can define the properties as movable property, immovable property, and intellectual property. So all of us know about movable properties. So we can move one place to another place. Okay, immovable properties, land, building, is a fixed assets. So for example, if you look at any government servant, either state or central government servant, so they ask the government servant to submit their immovable properties every year to check their the properties assessment. Okay, so another property which the topic of discussion is the intellectual property. So even we can have some property even based on our intellectuals. Okay, so those are inventions and literature works. So the nature of intellectual property, it is creation of human mind, and also we cannot see physically, but it is like an intangible property, and also it has rights. The government bodies and the agencies can give exclusive rights for the ideas and patents, and also there are limitations. So even if you do something, so if you invent something, so we may not get the property rights for all the elements in the invention. Maybe some limitation. There will be similar limitation. There are some exceptions. Also the time bound, the validity. There is a period of validity for everything here also. Okay, and territorial. So that the property, this whatever this claim IP is limited to some boundary, some area within the some terrain. So there are some definitions about intellectual property. So it's related to literacy, artistic, scientific works, and also, for example, performance of artists can be a property, and the music directors. So that whatever the letters they may phonograms, so that can be patented. That can be as their property, and broadcasting some programs. Some broadcasting events or programs also be taken as like a property. It may not be under patent, so it will be like other property. And also invention in the field of human efforts or any attempt made by the human, and scientific discoveries, so which will reflect something to the society and useful to the society, and industrial designs. So if the company is coming with new design or new device, okay, and trademarks, service marks, and commercial names and designations, and protection against unfair competition. So there are two competitors. So one is a duplicate. So duplicate normally they do reverse engineering and also without any reputation. And if if their products are not meeting the functions of other one, so that to protect their rights, they may have this IP rights. So these are all treaties done in the last 2 decades, 2 centuries. Sorry, 2 centuries. The first one was at Paris in 1883, and also second one in 1886. They have done about protection of literary and artistic works, and also in 1961, so about new varieties of plants, International Union for New Varieties of Plants. So that was held in 1961, 72, 78 and 91, and Convention on Biodiversity in 1992, and Agreement on Trade Related Aspects of Intellectual Property Rights in 1994. And after the computer world, when started early 90s, so that internet treaty started in 1996. So these are the events and organizations met together, and they framed various policies related to this IP. The basic principles of this IP, there is a contract between the creator and legal authority. So for example, if I am the inventor, so that when I submit my invention to the legal authority, that is a patent office in India, so for my invention, my protection of my invention, and also there is a balance between the creator and the public interest. So the creator, finally, whatever I create, whatever I invent, it should be useful to the society or public, and the interest, that interest is also very important. So there are limitations and exceptions between these two. So major intellectual properties: the patents, industrial designs, trademarks, geographical indications, layout designs, topographies, integrated circuits, trade secrets, production of new plant varieties. So here, if you look at Indian Patent Office, they deal the first 3 things: patents and industrial designs and trademarks. And there are laws as per Government of India for IP. So these are all the act and the ministry who is dealing the act. So Copyright Act 1957 by Ministry of Higher Education, and the Patent Act 1970 by Industrial Policy and Promotion, and 2000, 1999 the Trademarks Act 1999, and the Geographical Indications of Good, the Registration and Protection 1999, and Semiconductor Integrated Circuits Layout Design Act 2000. Holding ministry is Information Technology. The Protection of Plant Varieties and Farmers' Right Act 2001. Holding department is Agriculture and Cooperation. The patent. A patent is an exclusive right granted for an invention, which is a product or a process that provides new way of doing something or offers new technical solution to a problem. Okay, so just I have represented 2 figures. I think all of you know about this dhotis. So we used to, there is a one problem with everyone, so that we either we can use a belt or we can use a thin cord in a rope. So here you can see these things. Some companies in Tripur, they have come up with a solution, and with kind of sticky material, so that it can apply, but you cannot see this kind of thing in all the manufacturers. So this is limited to some manufacturer who have filed their patent. And also the purse, keeping the purse, there is a pocket. Okay, so it's a limited rights for the inventor, so that they can use this kind of implementation in their product. So when they get the patent or the permission, so other manufacturer, they cannot use this kind of additions in their product. And the validity of patent is 20 years. So for example, if you take a 3D printing technology, now the manufacturing technology is going toward 3D printing, and the first 3D printing technology was patented by Stratasys USA company in 1981. Till 2001, other than Stratasys, there was no company to make 3D printers. So after validity of their 3D printers, now today there are n number of companies make 3D printers, and the next generation of manufacturing is only by 3D printing. So what can be patented? Invention in all field of technology, whether products or processes, if they meet the criteria. So any even any device or any equipment or any processes. Suppose if we say that this is the process to be made like this, and the process invented by someone, those processes and technology can be patented, and there should be some novelty. Okay, so these are the eligibility, novelty, and there will be some inventive step. So that other person, the common person, should not be able to do something. So that should be some invention should be there in the technology or the process, and also there will be utility. So that whatever we invent or whatever technology or the process to be invented, that should be applied. There should be application of the utility, the invention. And novelty and invention must not be known to public prior to claim by the inventor. Suppose if I am the inventor and if I am claiming for some invention, that should not be there in the market, or that should not be there exist in the literature, or should not be there in any of public forum. Inventive step would not be obvious to a person with ordinary skill in the art. So if something, it should be more than an ordinary person can do that, or that should be there should be some kind of incremental the invention should be there, and also in industrial application. Okay, so if you look at some of our the products, so based on the need, only we have done some work that I will be able to make a presentation in the later part of the slides. The grant of patent. So there are patent offices in India in 4 locations. So I'll be providing the details. And after submission and after examination by the patent examiners or by the experts. So suppose if I submit something new patent application, so which is not able to examine by the examiner, so always they will forward the patent application to the experts in the field, and they get their opinion. So based on that, they will award the patent. And also in India, so there is opportunity for pre-grant or post-grant opposition. Suppose if after my submission of our patent, they will be publishing their website. If somebody says, so this was my work and I have done and I already have done on this, my product is in the market based on this patent. So that way somebody can oppose the patent application or patent, the content of the patent after the publications. And also the validity, there is a period of validity as well as on the terrain, that territory limits. So that in India we can submit our Indian patent, and within 12 months we may get opportunity to file foreign patent also. And also for Indian patent, foreigner also can apply. So these are the patent offices in India and their the restriction. And for example, patent office in Mumbai, so they takes care of Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh, and other union territories. And in Chennai, it's a southern region for Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana, and other union territories, Pondicherry, Lakshadweep. And New Delhi, these are the states: Haryana, Himachal, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, Delhi, other union territory, and Kolkata, the rest of India, northeast region. This patent office, addition to the patent, they can also do registration of design. Also, they can award trademarks. And you can see the patent offices. Using this link, you can find out the patent office link, and also there are the details. Many details are given in their website, so you can also go through in detail to understand more about the services offered by Indian patent offices. And there are some things which cannot be patented. So, for example, an invention which is not having any value or claims. Okay, so and also if it is obviously contrary to any well-established natural laws. For example, you know that there should be if you make any machine, the performance or efficiency will not be more than 100%. If somebody claims my machine works for 150%, so it cannot be patented. And perpetual motion machine, and if it is against Newton's law of gravitation, and it will not be. So many people, I had some similar experiences with some of them. They come with some proposals. They say that for example, an electric vehicle, so after once battery is the motor is running, again the wheel is rotating, again when the wheel rotates again, we can charge the battery, and so that without power the vehicle will run. Okay, so then I think without understanding the law of energy balance, they used to propose like this. And also somebody says that when we start rotating the flywheel, so due to the mass of the flywheel, it rotates, stores energy, it will rotate continuously. So this kind of proposals, this kind of invention proposals, so will not be considered for patent, because of they are not following these laws. And some more items. Okay, so for example, a machine whose primary or intended use against society, against the public, and against the moral value of the people. Okay, so animal or plant health to the society, and such as gambling machine and device for house breaking, against which can support for anti-social activities, and biological warfare material, or like a terminator, so to anything to kill the people, to kill the animals, which are not allowed to be patented. And some more thing, there is nothing in discovery, but they claim that there is I have found out something. So somebody is proposing that based on his understanding, for him it may be a discovery, but if you look at scientific principle, it is not any element or any discovery, so that is also not considered. Also, if any abstract, so without any valid validation or input, valid concepts, so only only abstract cannot be given as a patent. And are also discovery of any living thing or non-living substance occurring in nature is not considered for a patent. And also any discovery adds to the human knowledge by disclosing something are not seen before, whereas invention adds to human knowledge by suggesting an action resulting in a new product or new process. Okay, so there this against any the principles and natural laws are not patentable. However, if you develop something for some like apparatus or equipment or any utility, so for new technological application, so that will be considered for patent. Also here you can see some more non-patentable items, and form of new substance. Somebody claims some kind of material. If they found out some new material, they say, now I found out some new material in the my land or my place, so I want to get patent rights for the item. There may be some maybe somebody claims. I think I had some experience 2 months before. Someone came from Andhra Pradesh. They brought the material, a very shining material. Then he came to us, this was found out from my land, and the huge amount of by digging 4-5 feet I'm getting this kind of material. So then immediately then you can find out that composition of the material. So we found out that it is only a iron oxide. Okay, no, he said no, something is there, it is very heavy, so I want to find out something for new application, I want to do something on this material. Okay, so this kind of discovery or finding material may not be patented. And also any new property without any value, so will not be used for patent. Or also any machine or apparatus with a small without any value addition, so cannot be patented. And also some more items like mere mixture, so something adding some components and producing some subjects, so some elements and getting something. So that is, if it is exist in the market or if it is exist in the research, so will not be considered for any of patent examination. And at the same time, if they add some ingredients and if they add value to the property, and that will be considered. For example, like a soap, detergent and lubricant. Suppose you know that lubricant generally used for cooling purpose, for example lubricating moving parts in engine. And there will be, for example, if the temperature of existing one withstand up to 100 degrees Celsius. Suppose if you add some ingredients and if it withstands up to 150 degrees Celsius, so for such kind of ingredients and the value addition will be considered for patenting. And also integration of some known devices, so rearrangement of known devices or duplication of known devices, and even each individual devices are already patented. By combining that, if they find out new function or making it a device. And for example, you look at these 4 examples: a bucket fitted with a torch, say. So already torch has all this patented part, and a bucket, and like a umbrella with a fan, small fan. Okay, so these are the examples. A clock with a radio in a single cabinet, and floor mill with a sieving. So these are some examples. So those kind of devices, integration of duplication of devices, are not eligible for getting patent. Some more thing, method of agriculture and horticulture are not eligible to get patent. And also cultivation of algae and production of new form of known plant and preparation of an improved soil. And however, but this agriculture equipment and new equipment, automation, agriculture automation equipment are eligible for patent. Okay, so some more items: plants, animals in whole or any part. Okay, microorganisms, other than microorganisms, and but the seeds, varieties, and essential biological processes for production or propagation of plants, animals, and clones, new varieties of plants. Okay, so and also a process of production of plants.
I received this email regarding meeting.
A mathematical method or a business method, algorithms, or a computer program. For example, if you take a computer program, and that can be claimed as a record. Okay, so as a thesis, but it cannot be patented. Also, some more items: literary, dramatic, musical, artistic work, and any other aesthetic creation, including cinematographic work and television productions. Okay, those are having a copyright protection, but they are not patentable. And also you can see some of the examples for like a mental act, performing mental act, and our method of playing game. Okay, so solving a crossword puzzle, and learning language, method of teaching, learning are not patentable. Okay, but novel apparatus for playing game and carrying out scheme, some of games or scheme are eligible to get patent. And also the presentation of information and topography of integrated circuits are not eligible to get patent. Again, some more items. Just I will move through the slides. If you want, I can send you the presentation. I have less time now. And the industrial design. So all of us know design means the feature of shape, configuration, pattern, ornament, and composition of lines or colors applied to any article, whether in 2-dimensional or 3-dimensional models. Both forms an industrial process means of whether manual or mechanical or automated. So chemical, separate or combined in the finished article appeal to and are judged sold by the eye by visualization. Okay, so you can see a few of the consumer products has design value, and some of the pharmaceutical products, so which has design value and inverted at various stages. So the design of the textile, the patterns and jewelry designs. So example for the design patent. And some of my innovation with my team. The first one is a ceiling fan safety device. All of us know that ceiling fan used for hanging in India. Many, about 80% of hanging in India is by hanging in ceiling fan. And if you look at the load bearing capacity of the existing ceiling fan, it can support 200 kg. The weight of the ceiling fan is about 5 kg, but the factor of safety is more than 40 or 50, so that it can support up to 200 kg. But implement the factor of safety of 5 or 6, and if we provide some cutoff device, so which has been developed by our team. So you can look at, this is the device which is mounted between the roof, the hook, and the rod of the ceiling fan, and the cutoff load for this device is between 30 to 35 kg. So we have implemented this device's installation at IIT Madras hostels, about 8,000 hostel rooms, and IIT Tirupati and IIT Palakkad and IIT Hyderabad. So we have installed about 15,000 such devices in various hostels, hostel room ceiling fans. And just I want to show you one small video about demonstration of this device. So if you look at these devices, and this is one of our invention from our team, and also this was the origin for making one startup company, New to Make Innovative Solutions Private Limited, and also we have made few more products in the same company, and so incubated at IIT Madras. So another one is I am mentoring these companies. Another company is Vasitas Private Limited. So in 2015, I attended one pipe integrity conference in New Delhi, at that time, somebody from oil and gas industries told me that India is spending about 2,000 crores on oil and gas pipeline maintenance, out of which 1,500 crores are going to foreign companies supplying getting their material, and 500 crores only for a labor, Indian labor. So we started working on that area to repair oil and gas pipelines using composite material. So we based on that we published one paper. This is the paper. Nanofiller reinforced polymer composites wrapped to repair corroded steel pipelines, and these are the authors of the paper. And here the Viswas is the student who joined with me to work on this area, and then based on this publication, so this when we published this paper, the Viswas was in the final year BTech at IIT Bhubaneswar. Then at that time he registered on the startup company at IIT Bhubaneswar as Vasitas Private Limited. Then the same proposal, whatever the paper content, then he proposed to Indian Oil Corporation startup grant. He got about 85 lakhs to develop the product in 3 years. And from 2017 to till 2022, the 5 years, the company value has added from 0 to 50 crores. Now the company is value of the company is 50 crores, and Gas Authority of India Limited invested 5 crores in their company, and they are taking orders from all oil and gas corporations in India, like Indian Oil Corporation, Bharat Petroleum, ONGC. So they are helping them to maintain the pipelines. They are participating in huge tender of 50-100 crores tender. And now they have one R&D in Chennai, and they have planned in Noida. So they are able to provide employment to 50 plus technicians and engineers. So why I am telling this story, the reason is, since many of you are in academic institute, so you are getting opportunity to interact with the students to do some projects. So you have to find out the way to alert the projects, find out how to bring that the project, the idea to the market as a product. So if there are, for example, if there are 30-40 students, so all of them may not get a placement at the end of their course. If few students are there to go their own startup, they will be able to provide employment to few more people. So that's why that academic institutions, and there are more connectivity with the patent. The main reason is so that even the R&D organizations and academic institutions only can do inventions, and they can engage some young minds to work on innovative ideas to solve the societal problems. So always we need to find out some empathy on the society, and where there is a gap there, we need to work and we need to find out the opportunities. And I am also mentoring 2 more startup companies. The one, the third industry is a campervan factory. So now all of us know caravan, which is used to by only the film actors. Okay, so very soon a common man in India is going to get caravan for their tour and visiting some places. Okay, so here this campervan factory is the startup company of IIT Madras, and they have the collaboration with the Mahindra and Toyota to launch caravan. And this is the pilot caravan made in Mahindra Bolero. And actually I am advising them to make this body of the caravan using advanced sandwich material, lightweight material. And very soon, by June, July, the vehicle will come out in the market. This is a prototype. Already they've got approval all southern states, and also government of many of the states in India. They have made caravan policies. So very soon that even Tamil Nadu government is going to set up some caravan parks in different locations, so that people can take this vehicle and stay there and have a nice sightseeing and all. And another one, that fourth industry that I am mentoring is a Nanocoms R&D India Limited. So here, that security cabins. For example, if you look at the security people, So for example, if we look at the Chennai, then American embassy is next to the Gemini flyover. Okay, so there the Gemini flyover, we can see many the police people. They will be even during hot summer, so they will be standing in the flyover for 8 hours with a weapon, with a weapon, and to watch and to see the. So if you look at the temperatures and ambient, so we need to protect their comfortness as well as their protection. So if you look at some of the that airports and the some counters, embassy counters, they keep some sandbags. The security people used to stand or sit behind the sandbags, and with a weapon they used to watch. So just this is the bulletproof cabin made with some advanced material which can protect any kind of weapon in the world. Even it is a blast proof and bulletproof, and all three sides are covered with the bulletproof glass, and the room is small room. It will be air conditioned, and there will be cameras and internet and other facility will be provided inside, and very soon this will be coming to the market. So these are all my contributions towards invention and to the startup companies. So how the product or the research comes from the laboratory to the market. Okay, so so these are all my contributions towards the from invention, that laboratory to the products of the company. And also there are few more topics related to the registration. Okay, so the registration of the design is valid for 5 years, but it can be extended. And some more these are all the trademark, property mark, and artistic work are not included in the registration of design. Okay, so and you can see I can skip these topics. Okay, so the trademark, I think all of us know about the trademark. And you know that reputed companies, now this after COVID, you can see the hand wash. So earlier we used to get only Dettol as a hand wash. Now there are n number of companies. All the companies, the companies who manufacture this detergent or soap, so they make their hand wash because of their trademark, well known to the public or people. And even the patent office can do registration of a trademark, and the period of registration is 10 years. It can be renewed and extended, and the registration can be made only after examination and publication. So there are trademark, service mark, and collective mark. And the collective marks related to like of associations like Lions Club, Rotary Club. And the trademark, service mark is related to some kind of the service providers. Okay, so and also well-known marks. I think all of us know about different trademarks. And also these trademarks, there are different forms, maybe in letter form, word form, numericals, okay, and 2D symbols and 3D sign also. Okay, and can be also audio and musical notes. Okay, so these are all the things I can skip. And trade secrets, again, even somebody, if is not interested to go for if it is not eligible for patent, so they can maintain their secret. For example, if there's some production method, okay, even for example some chemical industry, and if they follow some kind of material combination, the elements combination, even if they don't want to reveal the combination to their employees and their operators, so they can give the code, and they can give us the code, and only the very confidential people in the top management can only understand the chemistry and the elements, so that others can use only the code language. For example, if you take the Krishna sweets, they have their own formula, and we cannot find out the same kind of taste and the same kind of quality with any other sweet manufacturers, sweet makers. So that they follow some kind of their own secret. Similarly, so the industries have their own secret on their product. Okay, and for, there is no limitation for that is a trade secret period, but whereas the patent, it is limited for 20 years. So here the trade secret, as I told you, by creating some codes, data, and high security toolings. Even if you look at some of the defense laboratories, they don't allow others to prevent secrecy. So similarly, industries also, some of the industries, even if they have their vendors, they don't allow their vendors inside their some of the areas of manufacturing to prevent their secrecy. And licensing again, that is between the inventor and that receiving agency, and maybe between the MOU between the inventor and the organization, so they can work to get licensing of the products. Okay, so the owners of IP prefer technology transfer through licensing only. And here again, the percentage and the payment upfront and part of upfront and after the sales depends upon the agreement between the inventor and the organization. So licensing is a profitable, and you can look at some of the industries. Okay, their patent licensing and their profit in the last 2 decades. Okay, so if there is any question, you can go through IP Indian Patent Office website. There they have frequently asked questions, and if you go through it, you will understand everything. And addition to that, if you need any information related to the startup, and if you have any other clarifications, always you can send email to me. And IIT Madras has IP cell. Either I can connect with you or IP cell for any technical clarification, or through my known sources I connect with the Chennai Patent Office. I have some references there, so I can help you out. Okay, so thank you very much.
Thank you so much, sir, for your elaborative session on intellectual property rights. Now I would invite Dr. D. Manjula, Assistant Professor of Commerce, to deliver the vote of thanks.
Thank you, ma'am. Good evening, all. It's a great privilege to me to deliver vote of thanks on this occasion. I express my sincere gratitude to our management, principal, vice principal for their continuous guidance and encouragement. Next, I would like to thank today's resource persons for first session, Mr. R. Arunkumar, Certified Patent Agent, Assistant Professor, Department of Mechanical Engineering, Ramco Institute of Technology, Rajapalayam, and for second session, Dr. G. Balaganesan, Senior Technical Officer, Central Skill Training and Fabrication Facility, IIT Madras, for their intellectual explanations. It was a proud moment of our college to have such an eminent personality. Had a great time. Thankful to both of you for joining with us. I thank Dr. Appiya Suganya for her welcome speech, Mr. Satish Kumar and Mrs. Manjula Gayatri for their chief guest introduction. I thank all the staff members, technicians for their support, and I thank all participants from all over India for your participation and cooperation. Thank you, one and all, for making this session as a grand success. Thank you.
Thank you everyone for your patient listening and active participation. Now let us rise for national anthem.
जनगण मन गति नायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा दब शुभ नामे जागे दब शुभाशिष माहे गाहे दब जय गाथा
जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे